It's a nice document to look at. And I also have some references to the books that I've found helpful that are written for, not for lawyers, but for lay people. And those of you who get interested in the Supreme Court might take that list of books and perhaps try out one or two. And then also back there are some actual briefs filed in some of my cases before the U.S. Supreme Court, so you can kind of check out what those things look like. They're little printed booklets, usually 50 or 60 pages long. Okay, well, let's get right into it. I think most Americans don't know very much about the Supreme Court, and the Supreme Court actually is the final decider on so many important issues that are before us. And it's not that hard to find out more about the Supreme Court. After all, there are 9 human beings up there who are the same as us, and they're not any way godlike, and they don't have any particular way of understanding more than we do. And the decisions they make are all political decisions and social decisions based on their own backgrounds and their own preferences. So there isn't any magic formula of the law that all they have to do is put it in the computer and the law will tell you what the answer is. No, the law is what the Supreme Court says it is, and the law, according to the Supreme Court, is what 5 people on that court say it is. And so there are many ways that we can influence the court, and I will tell you some of them as we go along here. Well, what is really significant is the court as a final decider about the separation of powers that our government rests upon. As you know, we have divided our legislative branch into 2 parts, and there's the executive branch and the Supreme Court, and these 3 branches in some way interrelate and give us the answers to our problems of government. And of course, there are also the states. If we look at the 10th Amendment, which I'm sure all of you are familiar with, it tells us something very significant to the court and to all of us. It says, the powers not delegated to the United States by the Constitution. In other words, specifically delegated in the Constitution to the United States. If it's not one of those specifically delegated powers, nor prohibited by it to the states, are reserved to the states respectively or to the people. So that little few words is a very significant aspect of our Supreme Court law, dividing up the powers between the federal government and the state, and it's still a very open issue. When this country was founded, there was a tremendous cleft between the way Alexander Hamilton and George Washington saw this country developing and the way in which Thomas Jefferson and James Madison saw this country developing. The latter saw that the states would be the most important element, and they were very concerned about too much power in the executive or the federal government, and they thought the way to stop that power was to divide the power to the states, whereas Hamilton and Washington felt that the federal government, to be effective, had to be strengthened. And they were very powerful in the beginning of our government. And our government is now a very strongly centered on the federal government. However, that's still an extremely important issue. In the Affordable Care Act case, the big issue was whether the federal government had the actual power by law to require people to buy insurance. Remember that? Mm-hmm. That was the big thing that separated out the Supreme Court. And actually, 5 of the members of the Supreme Court felt that the federal government had no power to do that, and therefore that part of the Affordable Care Act was unconstitutional because it was beyond the delegated powers of the federal government. But one other justice, happened to be Chief Justice Roberts, felt that the federal government did have the power to tax, and that it had the power to put this tax on, and therefore the federal government was allowed to continue to use the Affordable Care Act by a vote of 5 to 4. Very, very close case. And if Chief Justice Roberts hadn't been kind of like all by himself and saying, well, I find the power in the power to tax, we wouldn't have had the Affordable Care Act. So the Supreme Court has a lot of significant issues before it. And I'm going to spend the second half hour talking about what current cases are before the court that you'll be hearing about in the next 6 months that are decided by the court. The court sits in terms. It starts with the first Monday in October when the court convenes for the new term, and it usually ends up somewhere late in June when they've finished handing down their opinions. But the first half hour here is going to be spent on how the court actually works. And then we're going to have the last half hour on questions from you about the court and the issues before the court. Well, the court acts through cases, through actual disputes where somebody has something at stake. And I'm going to kind of follow through on one of those cases that I happen to handle. I was sitting in my little ACLU office in the early 1960s when the guy was introduced into my office as who had come with a complaint. And so I said, "What's your name?" "Leif Heilberg." "What's your complaint, Mr. Heilberg?" "Well, I can't get my mail." "What do you mean you can't get your mail?" They won't give me my mail unless I sign a little postcard that says I want my mail. And this is sort of very strange to me. And it turned out that there was a law passed in the late 1950s after the people who came to this country as kind of refugees from Hungary after the Soviet Union had so cruelly crushed their freedom in, I think it was 1958. And these people complained to Congress that they were getting all these propaganda pieces from Hungary, from the communist government now in Hungary, saying that they should come back, that it's so beautiful in Hungary, and all is forgiven. And they were very nervous about getting all this mail, so they did the American thing and went to their congressperson and said, "We're troubled by this." And so the Congress people thought that they would help out these Hungarian refugees, and passed a law that was signed by the president that said, if there is mail from behind the Iron Curtain, second-class mail, not first-class mail, but second-class mail, coming from behind the Iron Curtain, you had to tell the post office by means of a written postcard that you wanted that mail, or else it wouldn't be delivered. So I said to Mr. Heilberg, well, why haven't you sent in the postcard? What's the big deal? And he said, well, I hope to be a citizen of this country, and I know darn well that if I put my name on a list of people who want communist literature, they're not going to let me be a citizen. I said, you're probably right, Mr. Heilberg. So I brought a lawsuit, and we were lucky enough to win in the trial court, and the government took an appeal, and it got up to the Supreme Court. And now the Supreme Court has purely discretionary jurisdiction power. They can decide to take a case or not take a case. And I had a lot of experience with that, because during the Vietnam War, I kept trying to get them to take a case challenging the issue of whether we could be in a war without a declaration of war by Congress. And they never would take that case, and they never did. So it's never has been decided whether we can have a war without a declaration of war by Congress. But in any event, the government appealed, and the Supreme Court granted certiorari, as the word is, which means that they accepted jurisdiction. And suddenly I was in the U.S. Supreme Court, where I had never been before. And I'll tell you a little bit about the process of certiorari. Well, sometimes it's called cert.
Here's the top search result.
We'll just call it cert, because that's easier. So if there are 9 justices on the court, but it only takes 4 justices to agree to hear a case. So it's a minority of justices who agree to hear a case. But the actual decision has to be made by a majority of 5. So you can see that there are some minority views that get expressed in the court, which is pretty good. There's a particular rule about what cases they take, and it has to be an extremely important case, and a case in which there's a division in the lower court. Some lower courts have decided it one way and some another way, and they will try to solve the differences of opinion in the lower courts. But basically, the rule comes down to it, and at the very end of the rule, and it says, or any other good reason that the court, so they can take any case they want. But they make it very clear that they're not a court to bring justice to particular people. They are a court to decide major issues. If you can't get justice in the lower court, you're not going to get it in the Supreme Court, because they're not interested in just curing one phase of injustice. They're interested in settling major issues. So, what happens when a case gets to the Supreme Court is that there are briefs, written arguments filed by various parties. Each party gets to have, the one who lost in the court below has an opening brief, and then the one who won in the court below has a responding brief, and then the one who lost can respond to the responding brief. So there are basically 3 briefs that are in every case. But in many of these cases, there are lots of other people who are interested in the result, because it affects them directly. And so they want to be heard by the court too. And there is a process for that. It's called amicus curiae, friend of the court. And anybody who wants to file an amicus curiae brief, they have to get permission from the parties, which is very easily obtained, and they can file an amicus curiae brief. So some of the major issues have 30 or 40 amicus curiae briefs that are filed. Then after the case is fully briefed, it's set for oral argument, and each side has 1/2 hour to present its case. Most of the oral argument time is taken up with questions from the justices. The questions are trying to probe the attorneys on the more difficult parts of their arguments, and they're also meant to try to argue the case to the other justices, because before that oral argument period, the justices have never talked about the case among themselves. And then after the oral argument, they have a conference where they get together for the first time and kind of discuss the case and eventually come to a tentative decision. There's a process for deciding who will write the opinion, and another process for deciding who will write the dissenting opinions, if there are going to be dissents. And these written drafts of opinions are then circulated among the 9 justices, and they all can make suggestions. That's why it takes so long for a case to be decided. Many of the more controversial cases are not decided until 6 or 8 or 9 months after the oral argument, because there's so much back and forth and give and take among the justices until they can finally get 5 people to agree on one opinion. Sometimes they don't get that. They get people who are divided in their reasoning. They can come to the same result, but they get divided in their reasoning, which are called concurring opinions. And then there's no actual precedent-setting opinion, because there aren't 5 votes for any particular reasoning. There are only 5 votes for the result. One of the big issues before the Supreme Court is, how are we going to enforce our decisions? We don't have an army. We don't have any way to twist arms. All we have is our constitutional power to decide cases. And it's up to the executive branch to enforce decisions. So it's happened in American history that in the 1840s, when Andrew Jackson was president, the Supreme Court ruled that a large amount of land in the state of Georgia belonged to the Yazoo Indian tribe. And the state of Georgia did not want this land to belong to the Yazoo Indians, and either did Andrew Jackson. So after the Supreme Court decided that way, Andrew Jackson said, now the Supreme Court has decided it, let them enforce it. And he never did enforce it, and the Yazoo Indians have never gotten their land, and it's occupied now by private people in the state of Georgia. So always the Supreme Court has to be very careful that when it makes a decision, that decision will be such as can be enforced. And as you know, the very controversial Brown versus Board of Education, in 1954, they decided that segregation in public schools was unconstitutional as a violation of equal protection. But they said, now we're going to put this case over for another year and get everybody to decide how we're going to enforce this. So they got all these briefs for the next year deciding which way they would enforce it. And they finally came up with a decision in 55, that it would be enforced by the lower courts with all deliberate speed. And you know what happened to that. It's still it hasn't fully happened by any means yet. And the lower courts issue orders, and those orders can be punished as contempt of court. And that's the way the lower courts enforce judicial decisions. But it was very difficult to do it in the face of all the opposition in the southern states. So that's one thing that the court has to be thinking about. How are we going to enforce it? There are many little secrets to that. Let's go back to the very first case where the Supreme Court said we even have the power to find something unconstitutional. That isn't in the Constitution. It doesn't say in the Constitution that the Supreme Court has the power to rule things unconstitutional. And indeed, Thomas Jefferson and James Madison did not think the court had that power. They thought that the people in Congress and the people in the executive branch had just as much authority to decide what was constitutional as did the Supreme Court. So a case came before the court called Marbury versus Madison, in which Marbury wanted the then Secretary of State, James Madison, and the President to approve of a certain appointment that had been made by the previous administration of John Adams. And just as today, we have a lot of incredibly harsh political division in our country. We had that in the early days of our country when the Federalists were sure that if the party of Thomas Jefferson and James Madison was elected, the country would be destroyed, that these people were totally unacceptable as politicians to run the country. But nevertheless, Jefferson got elected and refused to carry out many of the laws that the Adams administration had passed. So anyway, the Supreme Court was faced with this question of what are we going to do about Mr. Marbury, who supposedly has this job, and Jefferson and Madison won't give it to him, and we don't believe that we'll be able to enforce our judgment because we're going to say, okay, the law says Marbury should have this job, but Jefferson is just going to say, you know what he's going to say. I don't want to get vulgar here, but it was pretty clear that Jefferson didn't care about what the Supreme Court said. So there was a very clever Chief Justice by the name of John Marshall, and he came down with an opinion along with his colleagues saying that yes, Marbury really is entitled to this job. However, he brought the case in the wrong court, and therefore there's nothing we can do about it. So that's the way the first constitutional issue was decided. The Supreme Court established its power to hold something unconstitutional, but was not required to enforce it because they had found some jurisdictional problem. And ever since, we've had what's called judicial review after Marbury versus Madison. I think a lot of us are concerned about, are wondering about what effect precedent has on the court, especially with the abortion matter being so still being litigated. How is this new court going to handle the question of is the abortion precedent going to be enforced or is it not going to be enforced? So I'd like to spend a few minutes just talking about how the court views precedent. First of all, I think it's pretty clear that if you are asking the court not to follow precedent, you have a little extra burden, because the whole premise of the law is that courts will follow precedent of previous court decisions, and that's so that people understand what the law is and how it will be interpreted. So precedent is extremely important to the whole process of the law. When can it be ignored? Well, sometimes the court will say, well, we've solved this problem, and it's been 10 years since we solved this problem, and it just doesn't work the way we solved it, so we're not going to follow that precedent. Or they're going to say that there are new social attitudes that have been developed since that precedent was established, and those social attitudes make it our job to change the precedent. And then there's the issue of reliance, which is going to be very important in the abortion case. People have been relying upon that precedent to say what the law is. If it's changed, that reliance will be overcome, and it will be very upsetting to those people who have relied. So that's another issue that they have to think about. But basically, precedent will be overruled if 5 members of the court think it's wrong. And that's about all we can say about it. In other words, when they want to overrule a precedent, they will. They'll surround it with all sorts of reasoning as to why, but basically it comes down to if 5 members of the court want to do it, they will. Now, some other things that people like to talk about is what about the law clerks on the court? How much influence do they have? Well, each justice has 4 law clerks who are usually recent graduates of law schools and in the top of their class, and very sharp, hard-working people. And the Chief Justice, by the way, has 5 law clerks because he has some extra administrative duties. So what do these law clerks do? How influential are they? First of all, I think it's great that these older people sitting on the court have young voices influencing them. It makes them keep up with what's happening in the world and not be completely isolated. So these petitions for cert that I mentioned, when people are trying to get the court to take their case, there are about 8,000 of them filed every year. And the Supreme Court only takes about 80, 1 in 100. Wow. So how do they do this? How do they read 8,000 petitions, each of which is 50 or so pages, and then there's opposition to the petitions, and there's reply to the opposition? By the time you're finished with all that, you have 100 pages times 8,000. That's quite a bit of reading. The fact is that the law clerks go through and read these petitions, and they make recommendations to their bosses. And if a justice wants to look at the actual written petition, of course they can, but they very seldom do. They wouldn't have time to do it. And the law clerks are asked to do specific tasks. They're asked to do some research. Well, how many states have this rule and how many states have that rule? What is the history of such a particular issue? Go to the Library of Congress and give me a memo about the history of this problem, how it's developed through history. And so they work very hard, and they bring a lot of information to the justices, and they're very important. But they don't decide the cases. The justices make their decisions, and the law clerks follow those decisions. I'm sure that they have discussions with their law clerks about the cases, and the law clerks might think that they're influential, and some of them are. Some of them can make suggestions that are picked up by their bosses. So the law clerks are important, but not definitive. Okay, now I want to get into the cases actually pending before the court now. I think the most important one is the DACA case, the deferred alien deferment of deportation. Okay, the reason that it's most important is that there are about 700,000 people now in this country who have been going to school, who have been working, who have established families, who are illegal immigrants. And they're illegal immigrants because they were brought to this country by their parents, who were also illegal immigrants. But they were brought as children. And why should they be faced with deportation for something they had no power to change, especially after they've established their lives in this country? Many of them have no interest at all in any other country, and they've made their lives in this country. So 700,000 people are at stake here. So I have to give you a little background, which is a bit complicated perhaps. Congress has the power under the Constitution to decide immigration issues. The President doesn't decide that. The Supreme Court doesn't decide who may immigrate into this country. The Constitution says the Congress does it. And if someone is in this country who hasn't been properly admitted, they're subject to deportation back to the country of their origin. So many times this is kind of harsh because people have come here and for one reason or another they've established families, they're married to U.S. citizens, they have children in school, this and that and the other thing. So Congress said the President in his or her authority has the right to defer deportation in cases of hardship. So the President has always exercised that power through the Attorney General and through the Immigration and Naturalization Service. And certain people have been able to show that that would be a great hardship on them and they shouldn't be deported, and they've had their deportation deferred. So then this question came up with all these 700,000 people who were brought into this country as children, and President Obama said in an executive order that anyone brought into this country under the age of 16 who hasn't committed a crime, who is either in school or has a job or has a family or something of that sort, I'm going to defer their deportation of this whole class of people until Congress can decide what to do with them. Because as you might remember, in the early years of the Obama administration, there was kind of a bipartisan agreement that to deport all these people would be extremely unjust since they were brought to this country as children. And so the problem was that Congress couldn't exactly agree on how this program should work, how they should deal with this. And they dithered on and on and on, and then a big anti-immigration movement started to develop and took over the Republican Party. And the Republicans then refused to do anything legislatively about these people who were in the DACA program. But they were protected by the President's executive order. Now this case says the people challenging this executive order say that the President interfered with the power of Congress by this blanket deferment of deportation. That is something that's like a law. It's not like an executive order, the argument goes, and therefore the president's deferment of their deportation was illegal. And that's what the big issue is before the court. Can the president have actually deferred deportation for 700,000 people? It's not obviously an individual matter, which is what Congress thought they were doing when they gave the president power to defer immigration. And so the Trump administration tried to revoke the deferment power on the basis that it was illegal. And the current case questions whether that action by Obama was legal because it approved part of the president's power under the Constitution or not. And also has an issue about was it properly done by the Trump administration when they rescinded the deferment of deportation. So that, I think, is the most important issue, and how it's going to come out is going to be very difficult to determine. I think the court is very cognizant of the fact that this is an extremely important case to a lot of people. Some of these people have had their deferments now for 10 or 12 years or more, and they've gone on to become adults in the society, and they've established families, and they have work that they're doing, etc. So, on the other hand, the court feels that it has to enforce the Constitution, and if the president has exceeded his powers and in giving this blanket deferment of deportation, it has to be changed. So we'll see what happens. I don't know exactly how it's going to come out. It's going to be a very difficult case. The next case that I would like to talk about is an issue that is also very controversial in this country. That is, do people? Well, let's go back and do a little more history here. In 1964, Lyndon Johnson was able to put before the Congress a law that said if there is racial discrimination in employment in large employers, that can be a subject of an action for damages, and also there will be established an Equal Employment Opportunity Commission to enforce this law, saying there can't be racial discrimination in employment. Now, at that time, the Southern senators were still very prominent in 1964, and they were filibustering against this law. However, they saw that their ability to filibuster was kind of weak, and they may not be able to get 2/3 of the Senate to agree to filibuster against this law. So one of the Southern senators had the brilliant idea that they would add an amendment to this anti-discrimination law that would kill it. And the amendment said, added to racial discrimination, also, you cannot discriminate, quote, because of sex, unquote. And they thought, no one is going to be wanting to give women equal employment opportunities, so that will kill the law. Unfortunately for them, it didn't work, and the anti-discrimination in employment law passed. So we have this law that says you can't discriminate because of race, and also you can't discriminate because of sex. Now comes our modern era, where we have a complete about-face about how we deal with people who are homosexual or lesbian or transsexual in our society, where nobody ever thought that this law would apply to them in 1964. But now, in 2019, it appears very logical that if you lose your job or can't get hired because you are of a homosexual nature or lesbian or transsexual, you should be able to sue under this law. However, is that because of sex that you're losing your job? The employers who are arguing against that interpretation say that no, they're not discriminating because of sex, meaning gender. They're discriminating because these people are following immoral practices or practices which most of society doesn't follow, and therefore we have a right to discriminate against them, and they're not being discriminated against because of sex. And that has an appeal, doesn't it? Because yes, it's true that they're not discriminated against because of gender, but how do we interpret this language? Because of sex. And this is one of the most important things that the Supreme Court does. Interpret the meaning of laws. What does because of sex mean? Does it mean just gender? Does it cover sexual orientation because of sex? Luckily, there's a few precedents here. There was a law forbidding people of different races to marry in the early part of this country's existence. And that law was challenged as being a deprivation of equal protection, that people of different races should be able to marry. These were state laws that prevented people from different races from marrying. And the states argued that they were not discriminating on the basis of race because men and women were treated the same. All races were treated the same. If you were black, you couldn't marry a white person, and if you were white, you couldn't marry a black person. So there was no discrimination, went the argument. So the same argument is being made here. This is not discrimination because of sex, because if you are a lesbian, you will be discriminated against, and if you are homosexual, you'll be discriminated against. So there's no because of sex here. So that's one issue that the court will have to decide in deciding this case. Another interesting precedent came up where a woman was fired from her job for dressing in a masculine manner. And she sued under this law of employment discrimination, and the defense was that she wasn't fired because of her sex. She was fired because of her behavior, the manner in which she dressed. And so the court was faced with that issue, is that discrimination because of sex? And they ruled, yes, it is, because a person is entitled to present themselves in any way they want, as long as they're not causing disturbance or interfering with the employer's job description or whatever. So that's a precedent that I think will be important here in the question of whether because of sex applies to discrimination because of sexual orientation. Basically, the argument of the plaintiff here, the people who are discriminated against, is that the law really is meant to protect against any reasonably comparable evil just like race discrimination or sex discrimination. And discrimination because of sexual orientation is a comparable evil. So the court has the power to interpret these words either narrowly, say sex means gender, or broadly, sex means, because of sex means any comparable, unreasonable discrimination. I don't know how that will come out. We'll see. Then there are a couple of criminal cases that are very interesting that are before the court. One of them is involves state jury verdicts in criminal cases. Do they have to be unanimous? One state, Oregon, passed a law way back in the early part of the 20th century saying, well, it's screwing up our justice system and costing us too much money to wait until we get a unanimous jury verdict, and therefore, if there is a vote of 10-2 for conviction, that will be sufficient. That came before the Supreme Court, and the Supreme Court said that's okay. You still have a jury. Then in 2018, the state of Louisiana passed a law. Oregon was the only state that did this, by the way. Everyone else and the federal government required that a jury be unanimous. And that kind of makes sense because, as you know, the test for conviction in a criminal case is beyond a reasonable doubt. And if you have 2 out of 12 people or 3 out of 12 people who say, we don't think that the defendant should be convicted, that may be a reasonable doubt in itself. Anyway, this case from Louisiana involving a non-unanimous jury by a Louisiana law passed in 2018 is again before the court. And the question is, should they follow that precedent from Oregon, or should they change the rule and say that in order to be fair in a jury criminal trial, the decision has to be unanimous? Is 12-0 really any different from 9-3 or 10-2? I would certainly argue that it is. It's much harder to get a unanimous jury verdict. So therefore, the state of Louisiana and earlier the state of Oregon is lowering the burden of proof in the criminal law. And if you go back to the historical precedents from England and the common law in England in the 15th and 16th centuries, was that the jury did have to be unanimous, which is a powerful argument. These historical precedents are powerful in the Supreme Court. However, the state of Louisiana says that it's just too costly, and they want to save the money by making it easier for the jury to come to these decisions. However, there's a little red herring in this. Not a red herring, but a little rotten herring. The state of Louisiana passed this non-unanimous jury verdict only after they were ordered to stop discriminating against black people on juries. So it looks as if what they were really trying to do was to negative the result of having black people on juries, which may be maybe 1 or 2 or 3 black people get on a jury. Nevertheless, in order to avoid this, what the state thought was a reverse discrimination of ruling that black people aren't guilty by having black jurors, they would have a non-unanimous jury. So when this case was argued before the Supreme Court, the question was raised about, well, was this passed for racially discriminatory reasons? And the one who asked that question of the lawyers was Justice Kavanaugh, the most recent Supreme Court justice, who everyone considers to be very conservative and reactionary. But actually, he was the one who was most interested in this issue. The state of Louisiana has a pretty powerful argument on its side by saying that if their procedure of allowing less than unanimous jury verdict is overruled or found to be unconstitutional, there will be 32,000 convictions of criminal cases in Louisiana that will be unconstitutional, and suddenly the state will be faced with 32,000 jury trials that always have to be done in a speedy way. And so they have a very practical objection to saying that the Supreme Court should not rule this unconstitutional because of this practical reason. Usually what the court does when that issue comes up, what will be the consequences of our decision, they usually say, well, we'll wait till that issue comes up next time. Right now we're just deciding what should happen to this particular defendant who is claiming that his conviction was unconstitutional. And maybe that's what the court will do again and avoid this 32,000 problem that the state of Louisiana raises. But these practical considerations are very real issues that come before the court. Let's see here. Oh, there's another important jury criminal case. The state of Kansas has abolished the defense of insanity. Every other state and the federal government allows people convicted of crimes to say that I'm not guilty because I was insane. And that test usually is, did you know right from wrong? Did you know when you were killing this person that that was the wrong thing to do? If you didn't know it was wrong, then in all the states except Kansas, you are entitled to a not guilty verdict, and usually sent to a mental institution until you get cured. And this happens quite a lot. Whether it's legitimate or genuine or not, I don't know. But in this particular case in Kansas, the man had killed a family member, and he said that he thought this family member was a Martian who had been sent to kill him, and he was just protecting himself. Well, in fact, there was no indication that he was threatened in any way. But if you do the right from wrong insanity defense, he didn't know right from wrong because he really thought this person was a Martian who was trying to kill him. So in Kansas, that's not a good defense. So the Supreme Court is faced with the issue of should they say that Kansas cannot abolish the insanity defense for reasons of moral or philosophical or whatever word you want to use, that insanity should be a defense, and it's unconstitutional to eliminate insanity as a defense. So that's a puzzle that the court will be deciding. Usually we say, the court says lots of times that, well, the states have the right to experiment in things like criminal procedure. And if one state wants to do it one way, another state wants to do it another way, that's perfectly fine. Maybe they'll find out which way really is the best way, and then that will eventually come to the most workable result. So experimentation is encouraged among the states, but this experimentation may have gone too far. Another interesting case before the court, and it's almost time for our question period, so this will be the last one I'll talk about. is religious aid to schools. That has long been an issue before the court. As you know, we have an establishment of religion clause in the First Amendment that says religion shall not be established by the government. How that actually is interpreted has been a matter of a lot of controversy. But in this particular case, the state has its own constitutional prohibition of religious aid to religions by the government of the state. And the claim is that that prohibition in the Constitution of the state for religious aid is unconstitutional as interfering with freedom of religion, which is another part of the First Amendment. There is freedom of religion, and they say that by prohibiting the state from aiding religious schools, they are interfering. This constitutional provision of the state is depriving people of their freedom of religion. That comes up a lot. One of the most interesting issues was involved the use of peyote by certain religious tribes, and the use of peyote was a federal crime, and these people in the Indian tribes who were using it were convicted of crimes, and they claimed that they were only following their religious views and they shouldn't be convicted of a crime. But the Supreme Court rejected that rule and said that laws of general application have to be applied even if there are religious objections to them, because everybody has to follow the same laws. Now, Congress was very upset about that, and so were a lot of liberals, and the conservative evangelical churches were upset about that. So the religious right and the liberal left got together, and they got Congress to pass the Religious Freedom Act, which said that in order for a religion to be, in order to convict someone of a crime for following his or her religion, there had to be no other way in which the government could enforce its criminal provisions, and the presumption was against it. And so this Religious Freedom Act now is coming before the court frequently too, with you remember the Hobby Lobby case a few years ago, where the owner of a business had said that it was against his religious principles to pay for his employees' insurance coverage of contraceptive care and birth control care, and the Supreme Court approved of that because of the Religious Freedom Act. So that's a very important religious freedom issue as to aid to schools that's coming before the court. And I think I'll just stop right here and use the last half hour for questions. If there are any questions, maybe I've solved all the problems. Yes?
I have a question. So, City of Berkeley Unified School District rents a piece of a public school on Sundays to a Korean Baptist church for religious services. Is this legal, do you think?
I didn't quite hear that, so you have to say it again.
Berkeley Unified School District rents a piece in the public school for Korean Baptist religious services on Sundays. Kosher?
Well, what do you think? Is that a violation? And does that involve the City of Berkeley in supporting religion? Or are they just saying, our room in the school is available to anyone who wants to rent it.
Well, maybe some innocent person walk through and get converted, I mean.
Yeah, could happen in that room.
If they're not or actually proselytizing religion, it's okay?
In the public school. Of course, proselytizing religion is okay in the general public, but is it okay in the public school room? I think the answer to that has been pretty well established as yes. That as long as they're renting their room to anyone who wants to rent it, they can also rent it to a religious organization without violating the First Amendment.
Thank you.
Yes.
Roe v. Wade.
Is that Mike?
When Roe versus Wade was decided upon, did the Supreme Court consider jurisdiction, because it's so being whittled away by each state's action now? Wasn't there a way to put the brakes on that in the whittling away of the law?
Well, the issue of the states prohibiting abortions, and at that time when Roe versus Wade was decided, the great majority of states made abortion a criminal offense. And the court, in overturning that, didn't say that you can't regulate abortions. They recognized that abortion is a medical procedure, and of course the state can require that it only be done by a licensed physician, and that it must be done in a sanitary facility, etc. So they can certainly regulate abortion. And that's what all of these states are trying to do, to creep up on Roe versus Wade by saying, oh, we're only regulating the way in which abortions are accomplished. For instance, now before the court is the issue of whether the state can require doctors who perform abortions to be admitted to their local hospitals. And the fact is that admission to the local hospital is usually a very discretionary thing, and the hospitals usually have rules that say that you have to practice in our hospital. You have to perform operations in our hospital in order to be admitted into practice in our hospital. And people who do abortions don't do it in the hospital. It's a relatively minor procedure, medically speaking, that can be done as an outpatient thing. But because they don't have hospital experience, these doctors are not able to be admitted to their local hospitals, and therefore states are saying they shouldn't be allowed to perform abortions, because that's part of our right to regulate the practice of medicine. So all of these little things are going to be considered by the court, and under the test of I've forgotten the exact words that the court has used in the past, but it was something like, is the regulation that the state proposes essential to the performance of its duties to regulate the medical profession?
Or is it overreaching,
Or is it just made up? And most of these restrictions on abortions in the various southern states and other states that have restrictions are kind of made up, and it's very clear that they're made up. But one of the things that the Supreme Court hates to do is to question the motivation of legislative bodies. They try to just decide cases on the basis of the way the law looks, by the words that it was phrased in, not by the motivations of the legislators. So the fact that these legislators had the motivation to restrict abortions in any way they possibly could is supposedly not relevant. However, I think it is relevant because it's so obvious and that's what they're doing. And by the way, speaking of Roe versus Wade, I have to tell you that that was decided by a vote of 7-2 that abortions could not be made illegal in the states because there's a constitutional right of women to decide on their own what should be done with regard to pregnancy. That was decided by a 7-2 vote. 5 of those 7 were Republicans. The other 2, one was a Democrat and one was a Republican. So you can't decide how, you can't figure out how a court is going to vote just by their party or which president appoints them. There's a big tradition in the law of being impartial, applying the law impartially. And lawyers and judges are very influenced by that professional rule of impartiality. And I think that's going to be always extremely important. So they're not just going to be deciding cases on a knee-jerk reaction.
I'm interested in the religions of the court members. Right now, there are no Protestants on the court.
No, there's one. Kavanaugh's Protestant.
I beg your pardon. The rest are either Jewish or Catholic.
Right.
Does this have a significant bearing on their rulings, do you think?
Well, you know, that's something that I wouldn't be able to answer. You'd have to answer that yourself. I can just say that even though there's a majority of Catholics on the court, there are, let's see, I guess there are 5 Catholics on the court, 1 Protestant, and 3 Jews. So there's a majority of Catholics on the court. Does that mean that because Catholic doctrine finds abortion to be immoral and unpermitted, that they're going to vote to find that abortion can be criminalized? Not necessarily. They are supposed to be above their own particular religious standards, political points of view, etc. Now that's very hard to actually do. They're actually obviously influenced by their own moral beliefs. Whether they're able to overcome those moral beliefs and say that I'm a judge, I have to be impartial, I can't be influenced by my own personal moral beliefs, is up to each justice, so I don't know. Anyway, I think that's, you know, very interesting that there's a majority of Catholics on the Supreme Court. Yes?
Yeah, thank you for coming tonight, by the way.
Thank you for coming.
I have a question of like limbo. If like there's a decision that's appealed to the Supreme Court, and obviously if the Supreme Court doesn't take it up, the lower court ruling stands. But how long does the Supreme Court have to make that decision? The case in point is this one about Trump's financial...
Yes.
Tax returns.
Yes, that's going to come, the question of whether the state of New York is entitled to subpoena Trump's accountant to get his tax returns will be coming before the court on petition for writ of certiorari, and there's no time limit at all. They can, and they do hold these issues for years. I had a case that was held for 3 years and involved agricultural laborers and the ability of labor organizers to get into talk to agricultural laborers, and it was pending before the court for 3 years, and the government kept changing its mind and saying, oh, this problem is going to be solved, and they never did solve it, but finally the court denied certiorari. So there's no time limit. However, in a case involving so much public interest and importance as the Trump tax return, I think that they will see that they have to decide that quickly. And it will be decided quickly.
But there's no ruling, in other words, it can't...
There's no rule, there's no law about it, yeah. Yes?
In your experience of sitting there in front of these 5 people, there's more people than that in the room, right? That are 9 people?
9 people,
9
yes.
businesses.
And then you have all kinds of assorted clerks and so on and so on.
Yes.
Were they giving you their full attention? Were they totally present? Were they talking among themselves? I guess it might have varied from case to case. Were you seen and heard?
All of the above. I can tell you one great time in my career. This case involving the question of mail and whether it was unconstitutional to require people to send in a postcard to receive their mail. When I argued that case, my opponent was Archibald Cox, who was the Solicitor General who represents the government before the U.S. Supreme Court. And he had been the Dean of the Harvard Law School and was very highly regarded as a legal scholar and a very competent, very important person in the legal pantheon. Anyway, Justice Black, who was then on the court, asked Archibald Cox, Mr. Cox, hasn't this issue of holding up the mail for people who say they don't want it come up before in American history? And Archibald Cox thought about it and he said, no, I don't think so. And then he looked back to his 3 assistants who were sitting at the table, council table as it's called. And by the way, they're all dressed in these tails. They wear penguin kind of uniforms from the Solicitor General's office. That's a tradition, and the court has many, many traditions like that. So anyway, the Solicitor General is up there, and he looks back at his 3 assistants, and they all go like this, no. So he said, no, it's never happened before. So fortuitously, as I was preparing my argument for this case, I was totally up to my ears with it, and I was just kind of wasting my time in the law library, and I looked up and there was this book. It was called Individual Rights, so I took it down just to waste time, and it opened by itself to this page. Really, it opened by itself. And there was a discussion of the fact that in the 1840s, Congress was considering a law to protect the people who didn't want abolitionist literature. And these people were saying, we were very upset that all this literature is coming at us in mail and advocating the abolition of slavery, and there ought to be a law to prohibit it. And so Congress was considering a law that if you put in a request to the post office that you were not to get any abolitionist literature unless you specifically requested it. So luckily, I was able to answer that question of Justice Black. Yes, this has happened, Justice Black. And I told them about how it happened, and I told them that also this proposed law about abolitionist literature was defeated in Congress on the basis that it was unconstitutional. So they all sat up and looked at me, and they were all writing notes, and they asked me what my reference for that particular bit of information was, and I gave them that reference, and it did appear in the actual opinion. We won the case by a vote of 6-3. So
Yay.
that was really a very highlight of that particular time in my life. So yeah, you never know what they're doing. They try not to fall asleep during the oral argument. But who knows? Sometimes they appear to be almost asleep. So you don't know. But they think oral argument is very important because they have issues and questions that arise as they're studying the case, and they're hoping that the attorneys will be able to solve their issues. Or also they use the oral argument to argue their case the way they want the case to go to the other justices, because as I mentioned, they don't talk about the case until after the oral argument. So it's very important, and you really don't know how much attention they're paying.
Is it on record?
What?
Is it on record? Is it
Oh, yes.
videotaped or so?
It's all recorded, and there's a stenographer, and they record them. And you can get the oral argument transcript from a case the day after it's argued. You go to the official United States Supreme Court website, and you go to the oral argument transcripts link, and you can get the transcript of, for instance, this DACA case that was argued about 2 weeks ago. The transcript is available. Yes?
Is it true the ACLU was supportive of the Citizens United decision, and if so, why?
The ACLU was not a supporter of the Citizens United, and Citizens United, by the way, says that is a very controversial ruling, 5-4 ruling that certain restrictions on campaign financing were unconstitutional, and that allows wealthy corporations and individuals to have a much greater influence on elections than they used to have. And so it's still very controversial. Certain people in the ACLU said that it's part of your right of free speech to spend your money any way you want, and to inhibit that right by campaign finance restrictions is a violation of the First Amendment. These people were not able to carry the day in the ACLU, but they made it so that the ACLU did not take any position on that case. So there's still a strong controversy in the ACLU about whether Citizens United is right or wrong. Yes?
What is the role of Chief Justice? Is he rated among equals, or is he primarily administrative?
He has a few little perks. Yes, he has all the responsibility of administering the court. But he also is, when they have this conference about the cases, he is the last one to vote. They all discuss the cases, and then they vote in order of seniority. So the youngest person in order of seniority votes first. The Chief Justice votes last. And that's an important place to be, because if it's tied 4-4, he can kind of manipulate a little bit and decide which way to go. Also, the Chief Justice is in charge of the oral arguments. So if people are all talking at once or something, he will say, wait a minute, let Justice Kagan talk, or something of that sort. So that's another little perk he has. But basically, he has one vote out of 9. Yeah, go ahead.
I lost my train of thought.
Yeah.
How is it decided who writes the opinion and who writes the dissenting and or the concurring?
Well, they try to kind of equalize it so that at the end of the term, each justice has kind of written similar number of majority opinions. So if a particular justice hasn't written an opinion yet, it's more likely that he or she will get the assignment. But the assignment goes to the senior member of the court who is voting that way. So the Chief Justice is always considered the senior member. So if it's 5-4 and the Chief Justice is in the 5, the Chief Justice will decide which of the 5 is writing the opinion. And if there's a dissenting opinion, the one with the most seniority in the dissenting group decides who will write the opinion.
And if you're dissenting, you can just say, I dissent, I want to write one. Is that right?
Oh yeah, you have they won't file their opinion until every justice has completely finished whatever he or she wants to say, written it out. That's why it takes so long, because they circulate all these drafts of opinions, and the dissenting opinions circulate, and they can try to change the dissenting opinion. And sometimes it happens that the vote in the conference is not followed because it's only tentative. And sometimes when a justice reads a dissenting opinion, he or she might say, well, you know, that dissent is right, I'm going to change my vote. So it's open for change until the filing of the actual opinion.
Do they file orally or by written?
Written. Yes.
You mentioned they get like 8,000 cases coming in, but they only choose 80.
Right.
And you talk about how they discuss it with their assistants. How do they actually choose the 80?
Well, they have this rule. It's Rule 10, as I mentioned, Rule 10 says if there's a lot of conflict among the lower courts, they don't like it that there's, if you have a case in California, it will be decided one way. If you have a case in New York, it will be decided the other way. So one of their jobs is to reconcile all of these diverse lower court opinions, and so that there's one uniform answer. So if a case presents that issue, it's likely to be granted cert. Things like President Trump's immigration ruling, where he in effect said that Muslims are disfavored for admission into this country. They're important enough so that it's an important case. So if it's a really important case, it will probably be granted certiorari.
And what are the mechanics of that choosing? Do they all vote on them?
No. What they do is they send into the clerk's office the cases that they want to vote yes on. And as soon as there are 4 yes votes, then that case is accepted. If there are 6 no votes, then that case is not accepted.
So if it's not accepted, then what the lower courts have ruled, if they've ruled equally, then what they've said goes through?
Yes, if there's an equal division among the Supreme Court, if, for instance, one of the judges is disqualified and there's a 4-4 vote, then the ruling of the lower court becomes the law. It is not the same kind of precedent as there would be from a decision of the Supreme Court. But that's what happens if there's an evenly divided court. Yes?
I always hear this term that, like, somebody like Scalia was a strict constitutionalist. I don't know if that's the right term, and that somebody else is more liberal in their interpretation. As you look at the court now, would you say that one or the other helps progressive ideas?
You know, there is a lot of talk about some people believe that the law should be applied exactly as it is written, and that comes out in this because of sex issue. discrimination against gay people is probably not because of gender. It's because of behavior, sexual behavior. So if you were a strict constructionist, you would say those three words, because of sex, are limited to gender. And there will be some justices who will vote that way. Other ones say, well, we have kind of a responsibility to interpret those words in a way that carries out the basic purpose of the law. And the basic purpose of the law is to eliminate arbitrary discrimination in employment. Therefore, we will read because of sex to include homosexual people. And other people are what are called originalists. There are lots of terms in the Constitution which are kind of broad and vague, like cruel and unusual punishment is forbidden. Now, what is cruel and unusual punishment? Is it what was cruel and unusual at the time the Constitution was written in the 18th century? Or is it what we consider cruel and unusual right now? So there'll be some on the originalist point of view and some not. But basically, I think most of the time, they decide these cases the way they think they should be decided. And then they say, oh, we're following the originalist interpretation or whatever. So it's kind of post hoc, made up afterwards.
That makes sense.
What about high crimes and misdemeanors? It's stated in your little book, high crimes and misdemeanors, but nobody knows what it is.
Oh yeah, well, two-thirds of the Senate know what it's in. So whatever two-thirds of the Senate think it is, it is.
That was...
Okay, looks like I've exhausted you.
This is
Thanks for
great.
coming.
Your expertise, really.
I know.